You're listening to Clause 8, the voice of IP. Today's episode, Mark Vallone.
You certainly want to look at the legal value and the business value and make the best decision that you can, get a lot of input. If you decide that you don't want to maintain, another option is to see if you can monetize that asset.
After you're finished listening to this episode, don't forget that we have a full archive of previous episodes in your favorite podcatcher. And when you're there tapping around, don't forget to leave a 5-star rating. And hey, tell your friends all about this great show. And now here's your host, Eli Mazur.
Today, we're lucky to be joined by Mark Vallone. He became Chief Patent Counsel for IBM in 2023. For almost 30 years, IBM led the U.S. in obtaining the number of patents per year. However, in 2020, IBM made the decision to no longer pursue the goal of, quote-unquote, numeric patent leadership. It went from obtaining over 8,500 patents in 2021 to, by some counts, less than 5,000 in 2022. Nonetheless, IBM remains one of the top American patentees. Mark, thank you so much for joining Clause 8.
Thanks, Eli. Glad to be here today.
So, I interview people from lots of different organizations, but IBM, I guess, has a special meaning to me. I knew about IBM before I knew about the internet, before I knew about patent law. And I think to a lot of people, to a lot of adults, that was the ultimate tech company back in the day. It just happens that actually my wife's mom, she spent her whole career at IBM. And I have two friends from around Poughkeepsie, New York. Both of their fathers spent their whole careers in IBM. One was a research engineer, a prolific inventor. Another one, which I find it actually much more interesting, is he was on the business side and he obtained one patent, but he remembers that memory fondly. And, he kind of lights up when he tells that story of why he got that one patent. So I think it goes to show about what a company IBM was and also the importance that patents played. So I'm excited to have this conversation.
I'm excited as well, Eli. Thank you for the invitation and glad to talk today about IBM and it's still a great company, great patent operations, and glad that we can get into some of that discussion today.
All right, so maybe we could start there. Why does IBM obtain patents today?
I think even with the change that you discussed back in 2020, I think ultimately a bedrock of our patent strategy is freedom of action, and a lot of that comes certainly through cross-licensing operation. Trying to save the business costs of legal proceedings and associated business disruptions is really important to IBM. Of course, we use our patents for defensive purposes as well. And another primary reason for obtaining patents is it helps drive our research partnerships. And of course, I think we still continue to benefit from our reputation that our patents give us. It helps us attract really, really great talent into our business and research. As you might be aware, we have 20 inductees into the U.S. National Inventors Hall of Fame that came from IBM, among other, very high awards like Nobel Prizes, et cetera. So that's an additional benefit of being in the position that we're in. So all very relevant in today's patent strategy as well.
Two thoughts come to mind. One is, you're taking on the ultimate Chief Patent Counsel role, I guess, in the U.S., following giants like Marshall Phelps, David Kappos, and Manny Schechter. How is it like to step into those shoes, and what is your role involved these days?
Wow. You say those names, and that's the only word that comes to mind is, wow, what a legacy we have here at IBM. And at the same time, wow, does that create an incredible amount of pressure? So, of course, Marshall was here in the role he was in before I came in IP law, but certainly leaves such a great legacy. I mean, back in the 90s, running an operation that was leaving $2 billion in licensing revenue annually is really amazing. And trying to convince another party to enter into a license is no small task, right? They're paying for the right to do something they had planned to do anyway, and now they have to pay you for to do that. They're not getting anything tangible in return. So that's a really difficult thing to do, and Marshall really had a way of getting companies to understand the value of taking a license, and so really great lessons from Marshall on that front. And of course, Dave Kappos became U.S. PTO director the year before I joined IP Law, so didn't have the opportunity to work with him in IBM, but I do know Dave now. It's been a pleasure getting to know him, and oddly enough, we have a connection in that one of his mentors while at IBM was the manager who ultimately hired me into IP Law. So thankful to Dave Adur for that. Manny, certainly, he's a tough act to follow, and certainly as I stepped into this role, there have been several folks outside of IBM that shared with me how they appreciate the way he always approached questions with a really balanced view, and that he didn't need to speak often, but when he did, his message carried a lot of weight. And certainly we saw that inside of IBM as well. But I can't say enough about what he meant to me for my growth as a practitioner, as a manager, and as a leader. He really took me under his wing over the past several years, and I harnessed all I could from that period of time. Oddly enough, what he had said to me at one point was, "We all stand on the shoulders of those who came before us." And I think it's really fitting of a patent attorney to be quoting from Sir Isaac Newton, who actually said, "If I have seen further, it is by standing on the shoulders of giants." So I'm proud to come from this legacy of giants, and really, it's quite humbling. So you had asked my question about my role today. So my role as Chief Patent Counsel for Americas, first and foremost is responsibility for our end-to-end patent operations, not just out of the U.S., but out of North and South America proper. And that's, life cycle from invention disclosure to patent issuance, right? So that whole end-to-end operation, associated policy matters. I help lead defensive patent matters for the company. And strategy, policy work, et cetera. So it's a large swath of responsibility, but really enjoying it so far.
So you described, I guess, why IBM has obtained patents today. How was that different in 2010 when you first joined IBM? What was the thinking back then?
So, back then was certainly in the midst of U.S. patent leadership days, right, where we were number one by quite a bit. Certainly, as I mentioned earlier, freedom of action has always, been a bedrock of our patent strategy. But numeric patent leadership is was certainly helpful. It gives you that a larger, large selection of patents against which you can use to help preserve freedom of action. Has a deterrent effect, right? There are, at least from an operating company perspective, folks tend to think twice about wanting to go up against such a large patent portfolio. So there's a bit of a different dynamic there. That was things back in the 2010 timeframe, and certainly we've changed strategies then. It's a very heavy focus now on quality and staying within our a focus on our strategic business areas. So a bit of a different take than before, but that's what it was in 2010.
When we say the goal of numeric patent leadership, were there non-patent benefits to that? Was there something that having 8,000 patents a year, individually those patents, maybe it's not worthwhile to get, but having 8,000 of them and being number one, there was some benefit to that. Was there some kind of thinking about that changed?
Yeah, well, certainly there's some benefit in that. Those larger numbers, I think, were even, and you opened the discussion with this, right? Everybody knows IBM. Everybody, understands the importance of patents to IBM. It makes people want to work there and be a part of such a great and talented workforce. So that was certainly a benefit of patent leadership. I think as well, a good benefit was that it really gave us a strong voice. What we said, and patent and IP matters carried, and I still hope today carries, a lot of credibility behind it. And those, I think, are some side, benefits of having that size of a patent portfolio, aside from, the legal benefits that we talked about earlier.
One of the strategies that IBM used at the time was they'd obtain a lot of patents, but then they would actively prune their portfolio. I think something like 60% of the patents. Can you talk a little bit about that strategy? And, there's a lot of companies out there that they prune about 0% of their portfolio. What advice would you give for them?
It's just a different strategy. Certainly maintaining when you're running at 9,000 grants a year, that's a lot to maintain, right? And certainly at some point, what kind of value you're getting out of that patent. And does it make sense to pay, maintenance fee for the entire life cycle? Probably not. Is it a perfect science? No. If I wish we all had that crystal ball to know exactly what was going to be, valuable, because sometimes you are going to prune at an earlier stage than one that maybe hasn't proven value after by the time of the 11.5-year payment. But it is an exercise in, you have so much money to maintain, and you're looking at what's bringing you the most value and what has the potential to bring you the most value, and trying to make strategic decisions around that. Other companies maintain the entire life cycle, but probably don't file as heavy as we do. Obviously, we were one of the top filers for a very, very long time. And so within a different budget constraint, you might be able to maintain everything that you file on. We just weren't in a position to do that. So, but it is an exercise in getting a lot of feedback, not just within legal, but from the business side, about what do we think is valuable to maintain, and trying to make the best strategic decisions you can around that.
What advice would you give to, I guess, another company that's thinking, well, maybe we should at least consider pruning our portfolio? Where do we start? How do we make those hard calls? I know you said you talked to a lot of people, but practically, how do you kind of even?
I think so. So practically, there's I'd say a lot of considerations. Look at your claims. How good are your claims? Are you able to discover infringement? Do you have divided infringement issues? So certainly that's going to give you an indicator of value. Where's the market going? Things like that, as to whether you want to maintain or drop. A big consideration out of it is just simply your budget, right? And if you don't have to drop, then you may not want to. But you certainly want to look at the legal value and the business value and make the best decision that you can, get a lot of input. If you decide that you don't want to maintain, another option is to see if you can monetize that asset, right? So you might want to look at selling it on the market. So, there's a lot of different things you can do with patents. That's certainly one of them, but you have to do what's right for your business strategy and your budgets, and act accordingly. So that's my advice. Talk to a lot of folks, get a lot of input, and make the best decisions that you can.
I mentioned, obviously, the decision to right-size the patent portfolio, almost slightly less than half. But are there any particular events, you were there, I guess, when those decisions were made, any particular events that stand out to you that kind of said, wait, maybe we should rethink getting so many patents?
Yeah, so that's a really good question, Eli. I've been asked that question quite often. I've been asked, was there a particular litigation that led to that decision, or was it the state of subject matter eligibility jurisprudence in the U.S. that led to that? And the answer to both of those questions is no. It was really a matter of, look, in a dynamic tech company, right? A strategy that has gone for 29 years is eons. That's, things change in tech companies all the time. Our innovation model within that 29 years of patent leadership really changed. When you look at the days, back when we were talking about Marshall earlier, right? We were very heavy on the hardware side, less software, mostly proprietary technology. Business has shifted, very heavy on the software side, still in semiconductor research, mainframes, but very heavy on the software side, consulting business. We rely heavily on open source software. We are involved in open innovation. So do you need 9,000 US patents a year when you have that as your innovation model? Probably not. And, it's a balance, right? Do we need 9,000 patents? Probably not. Are we going to look at a more balanced strategy? Yes, there are some circumstances where going trade secret is probably more appropriate, rather than putting in a patent something that's not discoverable and you're never going to be able to, are going to have difficulty enforcing that. So it's a matter of making better decisions, doing what's right for the business, protecting the business that we have, and recognizing that our innovation model is different, and that patents aren't really sort of the one size fits all type of a solution in this innovation environment. So that's really what it was about, rather than attributing it to any particular event. It was more of a, just as lawyers do, how do we best support the business given the state of affairs today?
Reading between the lines, it's public knowledge. The litigation landscape became more difficult. The licensing landscape became more difficult for enforcing patents. But that's not what drove the ultimate decision to right size a portfolio. It was really thinking more about, well, this is what the company is doing now. What does it make sense for in terms of the size of a patent portfolio based on that?
I think that's absolutely right. So, you mentioned difficulties in licensing. Certainly we're still actively engaged in cross licensing. That job is harder, right? In the current landscape, you have subject matter eligibility issues, efficient infringement, things like that. That all make that operation more difficult. But it doesn't mean we've stopped, right? So it really was a recognition of our changes to the business, and those other difficulties that you mentioned are things that we necessarily have to deal with, and I think all companies that are involved in licensing have to deal with.
So I'm curious about the practical mechanics, because I'm sure it's a question that comes up a lot for a lot of companies, right? Are they spending is their budget the right budget for obtaining the number of patents? Are they obtaining the appropriate number of patents and so forth? Is it something that you at IBM considered periodically? Like what was how did that idea even come from outside? It seems like a very radical move, but what kind of practically, how did it come about? What was the mechanics of that?
Well, I think it was just a lot of internal discussion and reflection, right? Every business is under responsibility to make sure they're putting allocating funds in the right places. So certainly there's a financial aspect to it. We're getting 9,000 patents a year is certainly an expensive operation. So you want to do the right thing there, but you also have to look at what's necessary, right? And we felt that the lower number was necessary based on changes to the business.
There's a question, I guess, it's not much of a debate, I don't think, but maybe you'll disagree, is quantity or quality more important for patents? I think most would say quality, but do you think there's still room for numerical goals? Is there importance to that? I think most large companies have some kind of numerical goals, which aren't quite, organic. They're just numbers set. Do you think there's room for that? How do you think about setting those kind of numbers?
Yeah, so I think that's a great question, Eli. I think in any strategy, you're certainly going to look at what are the volumes that your competitors are doing. And do I feel that I'm patenting at a volume that's enough to protect my business with respect to my competitors? So I don't think you ever get away from a numeric, component and what do we think is about right for our business, vis-a-vis our competitors. So, and then within that, you want to do the best quality that you can. So I don't think you abandon numbers. I think they're, certainly a part of the calculus, and you have to look at that in order to adequately protect your business.
Obviously, with the team you had there, you had the confidence to kind of make this change in course. I know a lot of in-house counsel who kind of discuss, we're thinking about growing the portfolio, reducing it, and so forth, but they kind of stay the course because that's always the easiest thing to do. It's a comfortable thing to do, and it's hard to kind of figure out to pull that trigger. I mean, what advice would you give to in-house counsel at other companies about, I know you said compared to your competitors, but I guess beyond that, practically, I guess, changing the direction. And, on the other side, what if a company says, somebody in in-house counsel thinks, compared to our competitors, we need more patents? How do you make that case within a company?
Well, I can speak from my experience. I mean, certainly going, lower after 29 years of U.S. patent leadership, it doesn't happen overnight. That's a culture that has built up over a long period of time. You're being more selective about what you pursue for patenting, and you're not selecting at the volume that you were before. Certainly your inventors are used to having more things go through, and so it's a big adjustment for them. And that takes time. Obviously was a big change for our inventors to adjust to. It was a big change for the attorneys to adjust through as well, because we also had to put that same level of scrutiny on that our technical evaluation teams were looking at with the incoming disclosures. And I would say, my advice is, whatever time period you think it'll take to adjust to going to a smaller size, put a multiplier on that because you're probably guessing a little short. It takes some time. If you're going bigger, you really need to put a business case behind it because bigger is going to take more money, right? And so what you're going to have to convince is your business leadership and finance, what's in it for the business if we're going to spend more on patents. Is it going to buy us, better licensing opportunities? Is it going to buy us opportunities for monetization? Is it going to help us land strategic partnerships? What's our expected return on that investment? You have to convince them it's the right direction for the business and what benefits that it's going to provide. So you really have to put a business case behind it.
You mentioned how difficult it was once you made the decision to implement it in place for the inventors as well. One of the changes that has been reported, I guess, is within the awards program the inventors were used to. Can you talk about the decision to make that change, awards, and is that part of trying to get less submissions? And any thoughts about the role of awards programs in general that play at company? You don't get it for other things you do at company, right? For special things, but that is a common feature that a lot of companies have.
Yes, I'm aware there was an article last week about changes in IBM's Invention Achievement Awards plan. We did, if you haven't seen it, chime in on that, and the article was updated with some corrections. It basically stated that IBM canceled its awards program, which is not true. The article discussed a certain aspect of the awards program that's no longer in effect. But really, the awards program was more around simplifying it. It's not gone. It was a program that had a lot of different tiers to it, and we simplified the structure of it. And that's discussed in the article. In terms of inventor awards plans in general, as you're probably aware, there are countries where by law you have to award inventors for either issued patents or disclosures, et cetera. And in those countries, they're entitled to that. We have a program that's much more broad than that and compensates inventors in all geographies. But I do think it has been helpful for us to elicit good ideas from our inventors. This is work that oftentimes they're doing outside of their day job, and I think it helps them justify putting that extra investment of time into things and to really give us well-developed disclosures. So I view it as a benefit. It's a nice perk for your employee base, and it encourages them to bring forth the type of innovation that you want to protect for the company, rather than saying, "Oh, I'm much too busy for that." Everybody's pressed for time, and it has to put their business priorities first, right? So I certainly think it helps for you to develop a good patent portfolio if you're going to recognize inventors within boards.
You started out at IBM, I guess, before your legal career as an engineer, and you actually won an award, not a monetary award, but an award for, I believe, one of your patents that was obtained. What was your perspective at the time? I guess you can empathize with engineers over there.
I can. So my story there is a lot like the one you started the call with. I had a really great experience at IBM as an inventor. I remember very well working with the attorney on the patent application. It was a really exciting time for me. I did get a patent application filing award, which we still provide under today's program. And so that was, certainly a welcome to me. It was, a really interesting thing when I started as an engineer, and I'm working with so many different prolific inventors that were in my group. It's almost like peer pressure. You want that feather in your cap too. Everybody else around you has it. You feel like you got to join the club. But it was interesting, and it was only then did I learn the importance of bar dates, because after I got my first disclosure through, I was like, wow, I did some really cool stuff I didn't disclose, and of course it went out in product over a year ago, and we were done for it. So I learned that the hard way. Yeah, I have gone through the process as an inventor. It's certainly part of what inspired me to leave and go to law school and pursue a different career. Really enjoyed the process at IBM. It's such a great operation, and that really was part of the basis for where I got today. So really great experience.
You went to law school. You became a lawyer, worked at some firms. I guess, what was the decision like? Come back to IBM in-house. What motivated you to do that?
Who doesn't want to join such a fantastic patent operation that's got at the height of patent leadership, and when you look at that legacy that we talked about earlier, I'm coming in, and Dave Kappos had just left to become the director of the PTO, and it's like, wow, they're asking me to join this type of an operation. That's so cool. So I naturally jumped at the chance to do it, and certainly glad that I did. No doubt about it. So yeah, it was a pretty easy decision to want to do that.
You had a pretty quick rise, I guess, to Chief Patent Counsel. I believe in 13 years since you joined. I mean, what do you attribute your success there at IBM on the legal team?
I think a lot of it was, I came in and I leveraged all of my knowledge as an IBM software engineer. I leveraged all of my knowledge from my experience in private practice and applied it in an environment where I was fortunate to be able to use both. And I think that really, really helped. I spent a lot of time developing skill in private practice on understanding my client's business, helping them obtain valuable patents and giving what I would hope was sound business advice, and took that same practice into the company. With clients I worked with in IBM, tried to stay ahead of their business as well, learn as much as I could about it so that I can provide them with the best advice that I possibly could. Try to get as much exposure as I could to different business units, work on projects for other business units where I can outside of my day job, and do the very best work you can. And I think when you do that and you make an effort to get to know your clients, both whether it's over calls like this, in person, and do a good job for them, I think that pays off dividends really well in a company like this. So that's pretty much how it happened, and it's been a great 13 years here.
Ooh, was it a dream of yours, like when you joined, that it'd be cool to be Chief Patent Counsel there one day, or?
Oh, for sure. I mean, absolutely. When you have somebody like Manny in a Chief Patent Counsel role, and somebody that we all looked up to, sure, that's something I think a lot of people aspire to, and it's still humbling today that even have been considered for doing this job. So it was certainly. Not many people can say they have a job that they've dreamed about, and so I consider myself to be really fortunate in that regard.
You give a lot of advice, but is there any one piece of advice that you would give to somebody going in-house at IBM or maybe another company about how to succeed?
Do the very best work you can, and good things will come to you. I think that's really what it is, Eli. When I think in it, and you boil down to it, the way I approached my career here is, I wasn't aggressively pursuing promotions and job changes. I just did the very best I could with everything I was asked to do, and to the extent I had time to do other things, I dove into other things and learned as much as I can. And I think that gets recognized when you do that. And I think if I had to give one piece of advice, that's it. Whatever you're given, knock it out of the park.
Is there anything you learned? You came from outside counsel and you brought that knowledge with you, but is there anything you learned about moving on to senior roles within IBM in-house that you didn't know when you were outside counsel, when you were beginning? Anything that surprised you or you along the way?
I think it's it's a big adjustment. When you're outside counsel, you're managing multiple clients, doing work for a lot of different folks. It's similar inside, but as you get more in the management ranks, there's different responsibilities that I hadn't had in private practice, right? So actually doing personnel management pieces, was new for me. And out the role I'm at now, and having, discussions among senior management, also a big adjustment. And I think it's a matter of, how was it put to me? Learning how to use your executive influence. And that's not something you do as a new associate in a law firm or even a new practitioner in a corporation. But when you get to these levels, folks look to you as one of the most senior leaders of the business. And you want to do what you can to try to influence what you think is the right direction for legal and the right direction for your clients, and use that influence to help drive those outcomes that might have been harder at a different level. And that's something to really get used to.
Is there anything that you wish you knew that you now know, I guess, from having a vantage point overseeing the whole, I guess, the patent program that you wish you knew as an outside counsel that you could have been even more useful than you were, or as an entry-level in-house counsel?
Wow, my first gut reaction when you asked that is, if I knew some of those things, maybe I wouldn't have chosen to do what I'm doing now. I guess what you don't know doesn't hurt you. But no, I enjoy the challenges of it. The way I take it, Eli, is our teams appreciate transparency, and I'm glad to be in a position where I can provide that to them. When we do a change in direction, right? So certainly, you've asked a lot of questions about IBM's change in patent strategy, right? Well, we had to communicate that internally, right? I mean, before it went out, to the general public. And how do you message that to your team and be transparent? And you want that. It helps build trust. It helps your folks build trust in their leadership. And it's really great to be in a position to do that, where you can provide them with that transparency, build trust, explain reasons behind decisions. It really helps them feel like they're part of the team, understanding company direction, and that you're being upfront and honest with them. And that's something I really value being able to provide at this level. So,
what is like the hardest part of your job now?
I think that's a great question too. I think it's managing such a fast-paced, dynamic business and staying ahead of the curve, right? I think that's going to be the case in any tech company, life sciences company. Things move at clock speed, and you have to react. You have to predict and give the best you can.
Is it about the technology changing, or
it's both?
Patent law
business
changing.
changes, speed matters, right? The quicker we get things out the door, the quicker we can make decisions, the quicker we can get back to a client. All of that matters to stay competitive, and you have to stay agile. You have to stay nimble. You have to give the best advice you can in that environment, and you got to keep up. So it's that's, I think, definitely been the most challenging from my perspective. Doable, but you got to stay on it.
So I actually want to come back to the patent portfolio development piece. Obviously, IBM has done a lot of it, and obviously what I do kind of interests me. IBM has used a lot of models to develop their portfolio, in-house prosecution teams, outside counsel, various counsel. I mean, how do you think about that question? What is the best? Who should handle that patent preparation and prosecution work? How do you answer that question?
Yeah, that's a great question. So we have a hybrid model. So we do some of our prep and process in-house. We have some of it go to outside counsel, and then questions become, well, do you use large firms or do you use solos? I would say, we have a mix. We have some smaller firms, we have some larger firms, and I think that model has worked really well for us. I can remember being in private practice where working with clients where things go in waves, right? So there would come a point where they're saying, well, budget got cut. We're gonna either pull all this work in where we think we can do it less expensively, or it's too expensive to have employees and we're going to shift it all out. And it's sort of one way or another. And there are these waves that go back and forth. We haven't really had a whole lot of that, because we've maintained a conscious decision that we want to try to do a certain volume of work in-house, and the rest done with outside counsel. And I think that's worked really well. I also think what's worked really well is, with our folks who are in-house that are doing that work, is, they're that much closer to the business, right? So they've got all of the internal insight that we have. They're able to take advantage of all our internal education programs that go take deep dives into various aspects of our technology. And I think that's a tremendous benefit to them. I also think it's a tremendous benefit to them that, when they're also in the role of reviewing work product that comes from outside counsel, they add that insight into the final work product. And so it's really sort of win-win that we've got folks on the inside that are firsthand doing that work. And so I think the hybrid model has worked very, very well for us. So I'm a big proponent of that.
Do you think there's a value to using outside counsel beyond the bandwidth issues? Like if you could have a...
Yes. And so that's a great question too, Eliza. As I mentioned earlier, it was intentional not to go all one way or the other. There is value in having outside counsel because I would say, with our internal practitioners, we have a great IBM view, but you all carry the perspective of also what's going out in greater, industry, and a lot of you sometimes, outside counsel satisfies a tech need that we may not have in house, right? So we're in some brand new needs technology that we maybe don't have the great expertise in on the patent legal side, and outside counsel adds tremendous value in that. So there are certainly avenues where having outside counsel is a great option for us, and that's why we want to retain that. So it's not. I don't view it as overflow. Our outside counsels are value add for sure.
Is there anything that sticks out to you that what the best outside counsel do? I create moments of magic for you, or
I'd say you can probably answer that question just as good as I could, right? Being an outside counsel. Right, so as an outside counsel, you strive to make life as easy as possible for your in-house, right? So you're doing the best quality work you can. You're doing it on time. You're doing it if your client is giving you sort of the contours of how they want you to do their particular work product for their company, that you're following that, and it's not just great support from attorneys. We are also looking at what kind of great support we're getting from their support staff, right? And that's I'd say equally as important. So we're looking at it across the board. So it's those that are delivering quality work on time, according to the expectations that we're giving to them, and those that are really proactive in reaching out to us when they have great ideas of things that we can improve and do better. We always certainly appreciate hearing that as well. So, those are the best in what I see in our outside counsels for sure.
I talked to in-house counsel at different companies, and what about to say it probably won't be surprising. They bring up issues. It's hard to control the quality, the costs, and so forth. I'm sure IBM, managing the size portfolio that you have, has thought a lot about these issues. What are the best ways to do it? I know you mentioned, obviously, you have in-house counsel who reviews the work and so forth. Anything that speaks to you on a continuous basis to make sure that you don't lose sight of these issues, even though initially you trusted outside counsel?
Yeah. I mean, certainly, through those types of reviews, right? We have in-house reviewing work products. We're able to keep a pulse on quality. Certainly we have data that shows us, whether our outside counsels are staying on, are on time with their deliverables. So there's, certainly data that helps with that. So probably the best ways that we keep gauge on that. And depending on how, in-house has their fee arrangements with outside counsel, that could be concern in some companies. There are other companies that work on flat fee arrangements where, maybe that's less of a concern because they know their outside counsels have to stay within those arrangements. So it just depends on, how the company's, financial agreement works with their outside counsels as well, in terms of, are things getting too expensive for us versus not. So, we have a good handle on that at IBM, and we stay close to our work product of our outside counsel, so we can keep a good pulse on all of that. So I think, with the system we have, it works out really well.
I want to take a step back, about quality control of a patent portfolio in general, right? As you mentioned, a lot of things change, the law of a technology, the business, but you filed these patents, I don't know, a year or 2 years ago. You're just finding out what the priority that's being applied and so forth. How do you make sure that the patents that you're getting are actually valuable and what you need and not are the reason why you have a patent program in the first place?
Yeah, another great question. So our inventions go through a technical evaluation by technical teams before they go to a prior art search. And so when you have at least a view from who we would consider to be subject matter experts in the relevant field, and how particularly valuable an invention could be from a business perspective, that's a great step one, right? So it's not legal making these decisions in a vacuum. It's done with great input from who we would consider to be subject matter experts. But then, as you know, even then, nobody has that perfect crystal ball, right? How many diamonds do you have, at the end of the day in that portfolio or in any portfolio? It's certainly a minority of the patents in an overall patent portfolio. And if we had better vision than that, we'd all probably be VCs and very rich. If you could tell what you had immediately. I mean, from what our experience, sometimes it can be really hard to determine what value you have for about 10 years into it, right? And because you're always trying to patent ahead, you're trying to patent ahead of the curve, and so it takes time. It goes back to the discussion we had earlier about maintenance, and if you're within certain budgets, and sometimes you have to drop patents early in the life cycle, it could be a risky endeavor, but you try to do it with the best decisions that you can. So the bottom line answer is we do the best we can on the front end to file on what we think are the most valuable. Through the course of maintenance, we try to make those same best decisions on what do we think is valuable in light of today's current conditions, because the initial decision to go forward might have taken place 5 years ago, right? So it's a different point in time when you're looking at it. You're constantly revisiting these patents and saying, what's today's value proposition? What do I think tomorrow's value proposition is, and what's the best course of action with that particular patent? So it's several points in time, I would say, throughout the process.
I'm guessing you have in-house attorneys who are responsible for certain portfolios, and they do that work. Is there anything outside of that, I guess, the stress test patents or revisit what's going on or anything like that, anything that you think works well?
You certainly, when we're reviewing patents, you're going to look at claim value, the scope of the claims. If I were to try to could I do a claim chart on this, right? I mean, is this something where I could actually try to map out an infringement case, right? So I think if you're talking in terms of stress testing, that's a really good stress test, right? Is this something that I even think I could build it into a claim chart? And that would certainly be, a part of an analysis that says, is this a patent that I want to maintain or drop? One factor that would go into it, so that, you consider that, part of a stress test. We have patents that get stress tested in litigation, things that have had difficulty at the PTAB or in district court. But yeah, certainly there could be stress tests throughout the life cycle of the patent, and that's a good way to do it. Is if I were to battle test this in court, or could I build a claim chart off of it? What would that look like? So.
There's a story that I think I heard either Marshall Phelps himself or somebody say about him, tell that Marshall Phelps, as you mentioned, he built IBM's licensing program, I think, into $1 billion revenue per year. But I think a new CEO came in who didn't have the same appreciation for patents as he did. And what he did was he took a computer or laptop and he put flags all over it. Maybe it was a computer, since this was long ago, to indicate everything is a patent or related to a patent. I'm guessing even at a company like IBM, there are people who don't have the same appreciation as you. You mentioned a bit about how to tell that story, but is there anything else that you think helps keep the importance of patents alive on a continuous basis at a company? That any advice for other places where it's not as built into the DNA and the culture as it is at IBM?
Well, I think we have a great example that's right close to us in Red Hat. Right, so Red Hat is, as you know, was acquired by IBM as an IBM subsidiary. As a company focused on open source, they're different view of you can imagine this pre-acquisition, right? A very different view of patents than IBM, and still is very different business model than the parent company and different take on patents. But they have a patent portfolio even as an open source company, right? So I think that's a great example where they're still able to invigorate an inventor community even with a very different business model. And they can stress the importance of having a patent portfolio in their business model as well.
And that they have a significant one pre-acquisition, or is that, I guess, something that IBM?
It's certainly a different philosophy. So do many patent at the volume of IBM? No, right? So Red Hat wasn't certainly patenting at our level, but they recognize the value of patents from a defensive perspective, right? And that you can't have zero or you're going to leave yourself vulnerable. And I think they've done a really great job at making sure that their inventors in their business model understand the importance of having some level of patents as well. So I think it's a matter of when you're trying to invigorate an inventor community, you have to explain how patents fit into your business. Every business is going to be different, but there is a place for, especially companies like ours and in Red Hat, how do they fit into the overall strategy and what value do they bring to the company? And I think when your folks understand that, and going back to the transparency point, then I do think they're invigorated to try to contribute to that effort.
So you and I actually met at IP Watchdog Live, where you were on a panel about AI, the hot topic of the day. But IBM actually was in the news back in '97, way before ChatGPT, for Deep Blue beating Garry Kasparov in chess. And it was fun to be preparing this interview to kind of go to some of those articles. I saw, I think it was about a half a year ago, speak on this topic. Has your thinking changed at all about the role that AI will play specifically with patent preparation prosecution?
I don't know that it's changed much since that panel discussion. I will tell you, I mean, it's an exciting time, and I see really, really great promise in generative AI. I will reiterate what I said during that panel. I don't see it as a replacement for lawyers or the human drafter, but I do see it as a potentially valuable productivity tool. I think it's incumbent on all of us to make sure that we're doing this really carefully, and a lot of that is going to come down to if you're thinking of using generative AI, especially if you're going to be using it to do any level of drafting of applications or responses, you have to be very careful around the terms of service, right? So especially when you're talking about an application, making sure you have the right confidentiality terms in place, that's going to be key. You have to be careful about, and this isn't particular to generative AI, but you have to be careful where the servers are. You don't want to have an export law issue. You have to be careful, as you well know, about where's your data going? Is it going to be used to train others? What's going to be injected into my application that may not have come from our inventors? And then what are the implications of that on validity? And of course, we all know the situation with Davis, right? That's not recognized, AI is not recognized as an inventor. And so you have to make sure you're claiming what has come from your inventors. And, you don't want to increase the risk of claiming something that came from elsewhere. I think, when you get through those hurdles, I think you've got, really good promise. If you can have generative AI that's output is sort of limited to a good arrangement of what's in your disclosure and maybe, a speech to text transcript of an inventor interview where they're elaborating on ideas from the disclosure, and you can get, that 40 or 50% first draft, maybe that's great. And then you have to, have, an attorney finish that off, but you just have to make sure you're steering clear of some of these other issues. And of course, that panel that you're talking about was an ethics panel, and what you have to disclose to your client in terms of getting informed consent that, hey, I'm going to use this generative AI in this, to draft this application. And I think, as time goes on, when some of those other issues become less prevalent and we're able to resolve them, then, things get a lot easier, and it'll be looked at a tool no different than we're using Microsoft Word to draft a patent application, right? But for now, it's new and there's legal challenges with it that we have to be mindful of. And I think that was a lot of the impetus behind that discussion that we had last fall.
And if you do get over all those hurdles, and now, what you describe is possible and makes sense. I mean, what gets you excited about it is that, we'll be able to save money on drafting applications. We'll be able to have more budget to do other things. Or is it, our attorneys will have better patent applications because our attorneys will be able to spend more time on them. Where you sit now, how do you kind of think about?
Yeah. So, I mean, and this is something that I think was talked about at the same conference that you were talking about, right? Is we're always even legal requirements are in the case law situation is requiring more and more robust disclosures. And when you're trying to do that on a fixed budget, that gets to be really difficult, right? Think of everything you have to build into a specification to try to survive 101 anymore, or issues of enablement and things like that. So one positive about generative AI and folks who have used it to try to generate a draft of a patent application is what it generates tends to be pretty robust and gives you a thorough specification. And I think that's a tremendous benefit because we're always under those pressures to build in more to the spec within the same amount of time or money that we've had to do it before. So having that added productivity, I think, is great. To the extent you're saving time, then I think it's great that you might have that extra time to pour into adding that more additional quality, into on top of what the generative AI was able to produce for you. So I think there's tremendous benefit there with a productivity boost. So that's what I would view. I mean, companies would decide what they're going to do with that end product, whether it's good enough or not. I would say certainly you want that human component to be looking it over and making fixes and that elaborating and making sure it's exactly the way you want it before it's filed. So I don't think you lose that human component.
So I want to end where we almost started, about that list of the top patentees in the U.S. Looking through a list, I see lots of foreign companies. You mentioned Samsung, but there's also companies like BOE and Huawei. And, Americans are not dominating the top of a list, as I guess maybe even I, as an American patent attorney, would maybe instinctively expect. Does that worry you? Is that something that should worry America?
Should it worry America? I'm not sure that's the case. I do think it is good to see that there are companies outside of the U.S. that see the value in the U.S. patent system, that see the value in having a patent portfolio with U.S. family members and recognizing that it's important to protect innovation in the U.S. And so that's certainly a positive. We want companies taking advantage of the U.S. patent system, no matter where they come from. So, as long as we are still an attractive venue for companies and entrepreneurs and solos and startups to obtain patents, then I view that as a positive thing. Would I like to see some changes to bringing us the absolute gold standard patent system? For sure, but it doesn't necessarily worry me that it's non-U.S. companies at the top. But again, just great to see that we have that perspective that patenting in the U.S. still is important to companies.
And is there one change that you would make, or you think that the patent community should be thinking about to, I guess, bring us closer to that more perfect patent system?
I would love to see us fix subject matter eligibility. I would love to see us restore that certainty to the system that I view is needed to attract that investment. Provide more certainty into that a granted patent is going to stay a granted patent, and justifies the investment in that. I think that'll go a long way to bringing us that much further ahead.
A good place to end, but is there anything else that listeners of Clause 8 should know that maybe we didn't cover?
A lot of times, like we started off in the call, a lot of people reminisce about the patent leadership days of IBM, but I promise you we're just as much of an IP powerhouse as we were back in those days. We're still generating fantastic innovation. You mentioned Deep Blue from 1997, but there have been some really great things that have come out in more recent years than that. Watson on Jeopardy, Watson Debater. I think you're going to see tremendous capabilities with Watson X, which is our generative AI offering. It's just an exciting place to be. So don't equate lots of patent leadership with stepping off the gas on innovation, because we certainly have not done that.
All right. Well, thank you, Mark. Thank you for joining Clause 8 and telling your story and IBM's patent story.
Thanks, Eli. Pleasure to be here. Thank you.
Thank you for listening to Clause 8, the voice of IP. If you enjoyed this episode, please share it with others and leave a 5-star rating in your favorite podcatcher. For more information, visit voiceofip.com. And don't forget to check out our full archive of past episodes. Clause 8 is a brouhaha audio production. Thanks for listening, and we'll see you next time.